Good afternoon, everyone. Thank you very much, Amit ji, for your very kind words, and it's good to see everyone here. Let me also add here, I'm also a CS by my qualification. I chose the practice of law, but I must very candidly say that it's very important to have qualification like a CS qualification, the kind of corporate laws and kind of education and curriculum we have. It's great help whenever we structure our transactions of mergers and acquisitions. Any aspect of writing an opinion, all that I studied, all that I still continue to study, and I still have study materials of CS Institute, it's very good, very good. One aspect is this. Second aspect is, I would also like to urge, is that although I chose the practice of law, my interaction has been with lawyers, my interaction has been with general counsels of companies, legal heads of companies who also have the designation of CS of the company. I think the profession as it is the kind of inputs I get from them, the kind of things that we do when we structure our M&A transactions is extremely good. But what I also see at the same time is that, people who are doing these kind of transactions, M&A transactions, they believe, or some of them they don't do, they believe that it's all happening in the courts, the schemes of arrangement, schemes of amalgamation, mergers, demergers. Of course, I agree that that's a very significant part of it which actually happens in the courts and which will happen in the tribunals. But so many things, like even when you have to write a shareholders agreement, it does not need any court's approval. When you write an investment agreement, when you write a private equity agreement, so many aspects of it, I still see that lawyers are doing it. I'm myself a lawyer, but I'm also a CS, as I told you. So much of which can still be done by company secretaries, even in practice, because you don't need a certificate to write a shareholders agreement. So I would strongly urge all of you to, try and also see if you can venture out in this space. In my view, I have been in this for the last 12 years, and I'm very passionate about M&A. And anybody who does it will agree with my views. It's a very good, great stream of working. So I will urge all my, professional colleagues here that do try and venture out, see how all these acquisition agreements, shareholders agreement, asset acquisitions, business acquisitions, how do they work. So with this, I will start. As I said, I'm very passionate about this entire concept of M&As. But today's topic is particularly only about acquisitions. So M&A is a very vast term, mergers and acquisitions. It includes a lot of things, but I have to concentrate only on acquisitions. Whenever I discuss with my mostly colleagues or in discussions, there is a general misnomer that M&A is only schemes of amalgamation. M&A is only schemes of arrangements or demergers. I disagree. M&A is very vast. There are many kinds of aspects of an M&A. I will focus on acquisition. Even within acquisition, there is a complete stream in it. There could be asset acquisitions, there could be share acquisition, there could be going concern business acquisition, there could only be acquisition of control. So whenever a work comes to us, the first question which we ask and the first question we see in the documents which are given to us, what kind of acquisition is it? What is it that you're going to buy? If my client tells me that I'm going to buy a company which is not doing at all good, so I will think as if that person is interested in doing, like we say, a bankruptcy takeover or a loss-making company takeover. So there are very different kinds of acquisitions. So when a transaction or when an assignment of acquisition comes, what we do first is to understand, because if I do not know what kind of acquisition that is going to be, I will read up the wrong law, I will read up the wrong provisions, and I can't structure the deal. So first and foremost things, so which is how I have designed my presentation also to apprise all of you, is that first, M&A is very vast. It's not only schemes of amalgamation and arrangement. It includes every kind of share acquisition, control acquisition, business acquisition, assets acquisitions. So this is the coverage. But within that, kinds of acquisition, as the name suggests, and you are looking at the screen there, it's a friendly takeover. 80-85% of the transactions are friendly takeover. Both the buyer and the seller, whether it is shares, whether it is assets, whether it is business transfer, whether it is control transfer, control acquisition, mostly they are cordial. So we don't have to worry much in the situation as we worry much in hostile acquisitions. There have been instances of hostile acquisition, but mostly it's a cordial acquisition. Both the buyers and the sellers are willing to do that transaction. But then there are also hostile takeovers, which are not still very popular in India. I still remember earlier, when you do a hostile takeover, many people still feel hostile takeovers are not allowed in India. I respectfully disagree. There's no hurdle. There could be hurdles in doing a hostile takeover because you are trying to acquire somebody's shares, some company's control, by not being cordial, because it's a hostile takeover. Of course there will be acrimony, of course there will be opposition, but legally hostile takeovers are even allowed in India, right? A lot of people still think that it's not allowed. What used to happen was, even the takeover code, it doesn't mention the word hostile takeover, but it is allowed. You can make competitive bids and all when somebody makes an offer for acquiring that company's share. So it's actually allowed. Earlier, sometimes ago, I think 3-4 years ago, any transaction of the nature of takeover score done by a non-resident required the approval of the government, FIPB, the Foreign Investment Promotion Board. So it never really had a characteristic of a hostile, because in hostile takeovers, you move very fast. But if you have to take government's approval, everybody will know, everybody will plan, and then they will find defenses to counter that hostile offer. But nonetheless, hostile takeovers are also permitted. Leveraged buyouts, the other category of leveraged buyout, those who have kept track of the aborted deal of Apollo Tyres acquiring Cooper Tires in the US. It was an aborted deal. It was a highly leveraged buyout, which simply means that when you acquire the target, when you acquire whether the shares, whether the assets, what you do is you don't fund it from your own internal sources. You do a borrowing for that. How much you borrowed determines whether or not it was a very highly leveraged deal or it was a low leveraged deal. Apollo Tyres is a classic case, and we were working on that, so I'm aware of the contours of the deal, but it got aborted for a different reason, that there was a problem in the factory in China, pursuant to which the deal eventually didn't happen. But out of 14,000 crores of acquisition, 90% of this was financed by the financial institutions, both Indian lenders and foreign lenders, to fund the acquisition. So that falls in the category of a leveraged buyout. Bailout takeovers, as the name suggests, is you try and target a soft company, which company is a very good case. You can buy the assets and shares very cheap. Generally, companies which are not doing good are generally the target of bankruptcy takeovers or bankruptcy acquisitions. The other kind is, of course, when you don't acquire anyone, two people acquire and form a joint venture, so they are joint venture partners in that acquisition. Demergers, I think that will be covered later on, demergers and spin-offs, and assets and business transfer. So sometimes you don't want to acquire shares of a company, you are only wanting to acquire assets, and a particular identified asset, a piece of land somewhere, or piece of factory somewhere, plant and machinery somewhere. So that's called an asset acquisition, which is different from a business acquisition. When you acquire business, we generally legally term it as a slum sale under the Income Tax Act also. So you acquire the entire business, up and running business. You will get the employees, you will get the contracts, you will get the license, you will get the plant, machine, contracts, everything of that business becomes yours. Suppose a hospital or a pharma company, not a hospital but a healthcare company wants to acquire 50 hospitals in South India. Only the hospitals, not the company. So it will be up and running with doctors, with everyone. So this will qualify as a business transfer, which generally is called slum sale, which is under section 180 of the Companies Act, New Companies Act. So as I said, that when I get a transaction of acquisition, I can't just start reading any law. Because if I get a deal or a transaction where there's a share acquisition, I will have to read a separate set of laws. If it is asset acquisition, I'll read separate set of laws. If it is business acquisitions, I'll read separate set of laws. But primarily in my experience I have seen is, I've listed out the kind of laws we generally have to encounter when we do any kind of acquisitions. I have divided the acquisition into two parts. One I call is a private M&A, the other is a public M&A. The difference is very simple. When an acquirer targets a listed company, whether in terms of shares, whether in terms of control, it qualifies as a public M&A. The only difference being that the entire SEBI guidelines start applying. Let's take an example, the Jet Airways transaction where Etihad picked 24% shares of Jet Airways in India. It's a listed entity. So advisors who were advising, and it was a great deal. We were not involved in that, but it was a very, very good deal. It's a delight for lawyers and professionals to read that deal. Every contour of deal was there. Every contour of law was there. Competition law, SEBI laws, FDI policy, you name it, everything was there. So that was a public M&A because the company involved is a listed companies in India. So if a company is unlisted, we say it's a private M&A. So the difference between that would be, you don't have to be concerned about the SEBI laws, SEBI guidelines, takeover codes, insider trading, but insider trading now applies to even private and unlisted public company thanks to the Companies Act, which I've also covered somewhere. So the law depends upon what we have to, what is the kind of M&A that it is. Generally in my experience, I have put together a list. Of course, corporate laws, as you know, Companies Act is the most important law because board resolutions, shareholders resolution, approvals, writing, issuing shares, transfer of shares, all of this form part of Companies Act. So of course the Companies Act, the corporate law. Contract law is very important. For example, you do not know the provisions of contract law. Somebody wants to acquire the entire business, going concern business. And the acquirer says that after I have acquired the business, you will not compete for next 5 years. You will not do that business for the next 5 years. If I am ignorant of the provision of Contract Act, I will fail in my duties. By the way, the Indian Contract Act does provide under section 27, nobody can be stopped from doing any business. However, there's an exception, and the exception is that if the business is sold as a going concern to someone, then the acquirer can put a condition on the seller not to compete for a certain period in a certain geography. So if these conditions are met, the clause which says, as we call as a non-compete clause, is legal and binding. So this is coming from Contract Act, from not from Companies Act or from any other provisions. Foreign exchange, FEMA. See, FEMA regulations is only applicable when there is an acquisition where the acquirer is a non-resident. So we have to also take into account FDI policy and foreign exchange regulations. Security laws, as I said, listing agreement, ICDR regulations, SEBI's takeover code, SEBI's insider trading regulations are all applicable when the target entity is a listed entity. Competition law, antitrust laws, competition laws are important. There is a 2011 regulation of competition under the Competition Act, which defines when and when not you have to take the approval of CCI. So there is a general list of exemptions also. So if you fall under those exemptions, you don't have to go to CCI. So I must know all these things when I structure the transaction. Taxation, I don't need to say about it. Taxation cannot be ignored. Cannot be ignored. You know, any kind of transfer of shares, transfer of assets, transfer of control, anything which involves any restructuring or structuring, you cannot ignore taxation. Stamp duty, of course, I think Satwinder ji will also cover this. Stamp duty, you know, shares, there's a stamp duty, asset you sell, there's a stamp duty. So there are important aspects to stamp duty also. Employment laws is only when you are acquiring a company which is very high on human capital. Imagine you are acquiring a hospital with doctors or an IT company where the professionals are, IT professionals. Most important concern for you will be that the employees should come because the human capital is employee. Imagine a professional service firm like CS firm, CA firm, lawyers firm. Most important aspect is the human capital there. So every advisor will focus on the employment laws, that everything should go right in terms of the employees who will come on the roles of the acquirer. Anti-corruption law, this has become more and more prevalent in the last 3-4 years, especially when the foreign acquirers, they are very concerned about whether the company is in compliance with corruption laws, otherwise they will not acquire those companies. Then of course the list is endless with respect to all the judgments which are coming. Because we are living in common law jurisdiction. We can't write laws of everything. We are not in civil law jurisdiction. So we can't write laws on everything. How the law evolves in our jurisdiction in India is that through the orders of the court, through the judgments of the court, they become the precedents. So this also becomes part of the legal laws and policy. Now, when we do acquisition, so important point is that how do we structure? That it's a very evolving thing. You know, in half an hour and 40 minutes, I will not be able to put across everything which I have on ground learned working on deals for last 12, 13 years. But still I'll try to give you the brief of how do we structure our deal. When a deal comes to me, what is it that I start thinking in my mind? What is the issue which strike me, which I try to overcome? So when we structure the deal, many people always will go into what is the law? Why is that law? Most people, in my view, forget the basic thing. What is the purpose of the deal? They answer why, they answer what, but they will never answer why do you want to do it? What is it? What is the law? How will you read the law until and unless you know the purpose? First thing is, when you do a deal making, you have to understand the objective of the acquirer, you have to understand what are the deal contours, and then start reading the law. And then you will be able to structure it better. So I have put objective at the prime. That's very important to know the process, the purpose. Second is, please understand what kind of acquisition you are going to do. Is it asset acquisition? Is it share acquisition? Is it business going concern acquisition? That will determine what kind of provisions and what kind of structuring you will do. Another aspect which is very critical is that what is the kind of company that I am looking for? Private, public, it's an LLP. What is the kind of, because it determines. If I am acquiring a private company, I will be reading a very different kind of provisions in the company law than I will be for a public company. Another aspect is, what is the level of acquisition? 5% or 50%? Because 50% I will write my agreement completely differently. But with 5% acquisition of shares, I will write it quite differently. So therefore, what is critical is also to know whether I am acquiring 26%, 50%, 51%, 49%, 74% or 100%. That's why I'm saying, if you even read these agreements of different levels of acquisition, every agreement will be different. A 100% acquisition share purchase agreement will be fully loaded with reps and warranties because I'm acquiring the 100% company. If I ask someone with 5% acquisition, give me whole reps and warranties in the agreement, the seller will say, please go off. I don't want to sell you the shares. I don't want to make you, what are you investing? 5%, and in return of 5% you want all lots of reps and warranties. So he has a strong bargaining power not to give me. Vis-a-vis when I acquire 100%. So this level of acquisition is also very, very important. Then important aspect of acquisition is, what is the instrument that you are acquiring? Now, if you are acquiring a debt instrument, the laws relating to CCDs or OCDs or provisions applicable to that will apply. If you are acquiring equity, different provisions will apply. So you must understand what is the instrument which will be used for the purpose of making that acquisition, that subscription to that, or when you are acquiring it. Important thing is that you have to decide what rights you will get upon acquisition. For example, a private equity investor who invests 15% in a company will get, say, a 1 seat on the board, or if not a seat on the board, an observer on the board. So you will have to get certain rights which we say the board and the management rights. Decisions, how will the future fundings will happen after you have acquired the company. Dividend policy. I have generally seen in the agreement being written that for the first few years the company will not declare any dividend. Later on, company will declare 30%, 25%, 40% of dividend to the shareholders because that's the source of revenues which the investors will earn. So dividend policy is also an important aspect. Then most critical part of any acquisition, say we are dealing with a shareholders agreement or an investment agreement, is the rights which you get. This is highly negotiated. The most difficult part for an advisor in my view would be is, one, when you have to structure the deal. It's very complex. You can't structure the deal because there are all the laws you have to meet, objectives, commercial objectives. Then more importantly is to negotiate. Because when you negotiate, because the other sides will pull and push their interests. I will push my interests. So where, in my experience, I have seen, If it is not a win-win situation for both parties, deals don't happen. They will only happen when both parties find some merits and some benefits in that. So when we write shareholders agreement, we have to be careful how we structure, because if the disputes don't happen, then that's fine. But when the disputes happen, and if your shareholder agreement, if investment agreement, acquisition agreement didn't have the clause to protect your client, then I'm sorry, you have failed in your duties as an advisor to them. So that's the real test at that point in time. So there are general clauses of transfer restrictions, tag along, call options, put option rights. All of these are part of the shareholders agreement. As I said, management and board rights, control. One aspect is very critical. Now the definition of control is also in the Companies Act. I have always seen that because if your acquirer does not want control in the company, please structure the deal in a way he doesn't get the control. But if he wants the control of the company, then please structure the deal as if he gets the control. Most of the time people miss this. Right, because the entire Jet Etihad deal, very nice deal, because SEBI said 24% share also Etihad was holding control, because the way the agreements were written, it controlled the management and policy decisions of Jet Airways in India. So it's very critical, because control triggers takeover offer, irrespective whether you acquire 25% or not. So I will fail in my duties as an advisor that I've structured the transaction in a way, giving the control to the acquirer when he didn't want. He'll say, what have you done? What kind of clauses have you written in your acquisition agreement that I have started getting control of a company where I never intended to get the control? So that is very critical. One question always comes up about veto rights, the affirmative votes, the reserved matter rights which we say when we acquire. A reserved matter right, a simple right. 2 people, 3 people agree that a certain list of reserved matters will not be done until and unless both the parties agree, or all the parties agree. That's called a veto right. There's a standard list like appointment of auditors, sale of company's business, change of company's name, declaring dividend, winding up of the company, issuing fresh shares of the company. So there's a standard list. The question is veto rights enforceable in India or not? That's a very critical question. I have a slide on this. I'll just okay, so this. So this is the slide of veto rights. So there's a judgment of Subcam Ventures. SEBI used to believe that veto rights give control on the company. SAT overruled that in Subcam Ventures judgment. The matter went up to the Supreme Court. Supreme Court did not pass any order because in the meanwhile the facts of the case changed. So as we stand today, it's a grey area whether reserved matters are enforceable or not. But the prominent view is, because in the absence of a conflicting judgment today on this issue, reserved matters do not lead to control. If you have to write an opinion, yes, you have to be a little considered when to write an opinion to structure a deal, but prominent view is reserved matters do not lead to control. However, if you are writing an opinion from a competition law perspective, so there's a judgment of multi-screen media where CCI or where the courts have held that for the purposes of Competition Act, reserved matters lead to control, because the purpose of both the statute is different. Because Competition Act has a different meaning of control. They want to see whether you have controlled so much that you can adversely affect or dominate the market position, your market position, or you can cause appreciable adverse effect of competition in India. So they look at it from a different perspective. So same issue, if I have to do a deal, if my client asks me, so I'll say, if you are asking me this question from the perspective of competition law, then because of multi-screen media's case, yes, reserved matters lead to control, otherwise, right now the view is they should not. So this is it. Then moving on this is, when we structure the transaction, we ask the question, what kind of instrument, what kind of funding is this? Is it going to be equity funding? Is it going to be debt funding? So how will you fund and what kind of instruments you will take as assets? This is very important. Most critical I have seen in my experiences also, when you have acquired a company, 2 people have acquired, which is a 50-50% JV, joint venture, deadlock, classic case, how to resolve deadlock. So resolution of deadlock is a very critical point of negotiation in a 50-50% joint venture. But there are standard methods to overcome that deadlock, as we say like, if a deadlock happens, the matter will go up to the senior people in the company and it will be resolved. In spite of that, if it does not get resolved, so there are mechanisms which we call our buyout arrangements. One person will offer the shares of the other. It's like a bidding. Whoever makes the higher bid buys these shares of the other one. So that's called the buyout option in a 50-50% deadlock. Sometimes when we do a private equity transactions and we take shares, we write very specifically that by taking these shares, everybody is agreeing that the promoter, the investor is not the promoter. Because the moment you become a promoter and you have not written the clauses correctly, if he qualifies as a promoter, then he becomes liable to every liability of a promoter, whether under the ICDR regulations, SEBI laws, and by the way, even under the Companies Act now. So therefore, this is very, very important to don't make him a promoter if he doesn't want to become a promoter, but make him a promoter if he wants to become a promoter of the company. That's how your clauses in acquisition have to read. I think acquisition of control we have discussed. Look for exemptions. Always look for exemption. All the statutes have a lot of exemption. SEBI will have a different kind of exemptions. Competition Act will have a different kinds of exemption. Look for the exemptions. Try to fit your case in the exemption. That's a very, very difficult. Good. When we structure our deals, we generally try to make it in a way so that it falls under one of the exemptions. The moment you are in exemptions, you will be out from that provision. So this is a very, very critical part of structuring this. This is just, I have put this is really not from person who acquires. This is from the perspective of person who sells, slum sale. Because this is a new provision which has come in section 180 of the Companies Act. So I thought I'll just include this. Section 180 simply says what section 293 1A used to say. So undertaking when you sell. Why I have included this slide is from one perspective. The perspective is that if a holding company is selling the shares of the subsidiary, 100% subsidiary, because it says, you are holding more than 20% of your investments and 20% of test which is given of an undertaking, holding company holds 100% of the subsidiary. So when a holding company sells the shares of the subsidiary, 100% subsidiary, and somebody acquires 100% acquisition, then does section 180 apply or not? That's the question. Even this question used to come under 293 1A. The judgment is a BPL communication judgment, landmark judgment on this issue, which says that in spite of selling the entire 100% share in a company, you are not selling an undertaking. So therefore, the view is, even if you sell a 100% share of a subsidiary, you do not sell the undertaking, and section 180 doesn't apply. One aspect which I said, when you are acquiring, there's always a debate. In 1956 Act, that debate was very valid. I have structured transactions after the acquisition. I have converted the company from public to private because many reasons. One is the compliances under the private companies were less under the old Companies Act. So therefore it's always easy. Your investor will like that, don't make it a public company. Just make it private, keep it private because the compliances will be less, some 44, 45 exemptions which were there. So the question is the debate worth now? Because the gap between public and private company, as you all know, has shrunk. So today, I simply tell my clients that, okay, fine, there are still 10, 15 exemptions for private companies, and if they are material for you, still insist on a private company. Even if you are interested to buy a public company, insist that public company gets converted into a private company. So this slide only shows that, is the debate worth it? I still feel it's worth it. Most important part, which was like a savior for share transfers, was private companies, the share transfer restriction was enforceable. Public company, it wasn't enforceable because there used to exist section 111A of the Companies Act 1956. Now section 58.2, you must all of you read it. Section 58.2 even says, even in a public company, you can enforce the transfer restriction provided the shareholders have agreed and you have incorporated in your articles of association. So even that, from that perspective, the debate has to the great extent shrunk. So this is, in my view, still there is some merit in private companies, and by the way, all of you must know that there's a notification which could be passed in this session of the Parliament under section 462, which came in June last year, proposing some exemptions to private companies. So if those exemptions are given, of course, then again I'll come back to a large basket of exemptions for private companies. Again, I'll start insisting that please ensure that the company is a private company because it's much better way. But I will fail in my duties if I see that a company has to go in an IPO and I'm insisting on a private company, because a company which wants to go for an IPO has to be a public company. So this is all we have to keep in mind when we do it. Then another aspect is about subsidiaries. When I'm acquiring, now I have to be very careful, because earlier under Section 4 of the Companies Act, when I acquire a company, it was only the equity capital. Now it's the total capital. So now if I acquire a company, if I hold 10% of equity capital and say 60% of preference capital, I make that company a subsidiary company. Because earlier, the only thing which used to be calculated was equity capital. Now it is equity plus preference also. So therefore, when I am acquiring, I must tell whoever I am advising that look, you are buying equity and also CCPS, compulsorily convertible preference shares. The total of the two could make it your subsidiary, provided you hold more than 50% of the total combined capital.
One question. What about the redeemable preference shares in this case? Will that also amount to the subsidiary?
I think the definition says compulsory. Does it say? I can check the rules. It says compulsory. I think you can. The rule has a definition, and I think it says
CCPS is okay, but not the redemption.
It says convertible.
We are just talking about that if it is convertible into equity.
Yeah.
They are not defined that whether it is compulsorily convertible or optionally convertible. That's still a grey area.
No, but I'm specifically focusing on the redeemable preference shares.
And that will
they are not covered.
It will not be.
Yeah, that's right.
Because it, I think, uses the word convertible. It's convertible. So if you are share, I think it is not covered then, because the definition, I think, in companies incorporation of rules says that.
Then fair.
So it's not covered. Good question. So moving ahead, as I said, promoter. I'll just take 5 minutes more. Do I have the time? 5 minutes.
5 minutes.
5 minutes. Okay, 5 minutes more. So I'll try and wrap it up. In any case, presentation you can share because I had specifically made for this session. So yeah, this one. So this is also important. I now have to focus whenever we are advising that, because the definition of promoter is very clear. It says something. So we see that what makes a person promoter, and we also apprise in our transaction that if you become a promoter by controlling the company, and there's a definition of control, then associated liabilities as a promoter. You know, breach of private placement norms, you know, you'll be personally liable under prospectus. And so this is also veto rights. As I was talking, I think the slide has come at the wrong place. It should be there when I was talking about the veto rights. These are the sample veto rights which I was talking about. These are your reserved matter items which we believe do not trigger control. But mind you, you are not, as if you are not talking about competition. If you're talking about competition law, then it is a problem. There's another debate which is happening now, and unnecessarily it's happening. And I tell some people who are very fussy in transaction, it's their ego issue. It's very, very important when you are doing a transaction, you are an advisor who's advising to make the deal happen. You have to keep your ego at rest. Sometimes what happens that people will still start their fight. That no, I want this right, I want this right. So I said, okay, most of the time they are fighting about rights, which the law has given you now. So earlier there were certain resolutions which you could have passed by ordinary resolution, right? And somebody who was holding 26% cannot stop that resolution, because the person who's holding 74 can do it. That list is now, if you know, a lot of things which were ordinary resolutions have now become special resolutions. So your fight is not worth it now. If you are holding 26% of a company share, you don't need that as a veto right, because that's your legal right. So stop fighting for those clauses, because you will achieve nothing, and other side will feel as if you have not read the law also. So if any one of these things come, now I've listed it here, I don't fight anymore. Earlier I used to fight for these things, because now the law protects me. I don't need that as a veto right in the transaction. Okay, then just 2-3 slides about public M&As. Now, when you do a public acquisition, first of all, they are more difficult than private acquisition, right? Because SEBI regulations and the way markets work and the way SEBI regulations work, they make it very complex. Only 2 or 3 regulations will apply in all the public amenities, and you must be aware of if you are acquiring that. And I'm sure of you must be aware of takeovers code. So what I have done, I've just made a chart of situations where takeover code triggers and where it doesn't trigger. So you have to just have a knowledge of that. Simply, when you acquire 25% of the company shares, the takeover code triggers. Even if you don't acquire shares, but if you acquire control, then also takeover code triggers, right? So that just says, irrespective whether you acquire shares or not, the takeover code triggers. So you have to see, by acquisition of shares is a mathematical calculation. Just see you are holding more than 25% of the company's capital, mathematical calculation. Some people take a view that compulsorily convertible instrument also trigger the open offer, not when you issue the instrument, only when they are converted into equity, the takeover code triggers. So it's still a mathematical calculation. But control, finding control or not is not mathematical. It's a very subjective thing. You have to think whether the person is controlling the management and policy decision, which will depend on the facts and circumstances of the case. So nonetheless, you have to be careful of this. In public M&As, be careful about insider trading regulations. Because when you do a diligence, when you are acquiring a company, doing a diligence, you are privy to inside information. So you will, by that definition, you are an insider. Since you are an insider, please don't trade in the securities, which is why generally companies write confidentiality agreements. Generally companies write standstill agreement, which means that you will not trade in the shares. Why? Sometimes people are not sure. Suppose the deal gets aborted, doesn't happen, abandoned. The moment the deal gets abandoned, they'll say, no, we can go and trade. No, there still is a caution. Don't trade till the public information becomes public. Because your deal is abandoned or is successful has nothing to do with law. The law is saying don't trade in the securities until and unless the information is public. Which is why, if you see now the new insider trading regulations, which will come into force from 15th of May, also prescribes the timing. You have to put it 2 days or some trading days before you close the deal. So they're curbing the things where in this. So this is what we do in, especially in public M&As. Last slide I think is of other issues. Mostly from Companies Act, New Companies Act. Do read section 186, because 186, when you acquire shares, when I'm acquiring shares of another company, even if I'm an individual, if I'm acquiring shares, or as an individual I will not read, because I'm not a company. But if a company acquires the shares, then please read section 186. It's a new section which has come, in the sense 372A was there, but with some more rules around it, exemptions for holding subsidiary, that you have to read. 179, which is an equivalent of 292 of the 1956 Act, is when you are investing funds, and you will invest funds when you acquire, then you will need a board resolution, not through circulation. Then section 67(2), which is equivalent of section 77 of the Companies Act, restriction on helping the company to buy its own shares. So you should, sometimes the clients get very innovative, they say, okay, we will fund some part of the share acquisition to my acquirer, he will buy from there. So section 67(2) doesn't allow, only it allows for category of ESOPs. You can help the employees, but you can't help the acquirer to acquire the shares. However, it doesn't apply to a private company. You can, in a private company, even fund it. So that won't be a problem. One question always comes to us, and I can share that question, and I won't give my view. You can discuss that view at the tea break or whatever, lunch break. Is most of the time it happens is that the trend is when you advise an investor, a private equity investor or any investor, the trend generally is the investor doesn't pay the fees of the professionals and lawyers. They expect the company into which investment has come to pay it. Suppose the investment is of 500 crores. So they'll say, okay, you pay the financial advisors and lawyers and everyone who advised it. Suppose that's 2 crores. The company pays it. A question comes, by paying that 2 crores to the legal fee or financial fee or professional fee of advisors, did the company help in that 500 crores of investment? Did that 2 crores help? If the company had not paid 2 crores, does it violate section 67 for public companies? Or did it violate section 77 under the old law? So that's the food for you. I have a view. I can share it with you, but you can think about it. Read this section yourself and we can. Okay, one more question which is coming in section 188. Now section 188 is a related party transaction. So the question is, when I'm acquiring shares, so whether 188 applies or not, the view is that if you are making a fresh issue of shares, means a primary issuance, one company issues to the other, even if both entities are related parties, say subsidiary and holding, section 188 doesn't apply in an unlisted company. For listed companies still apply because SEBI regulations have a different meaning of related party transaction for share acquisition. But if you are doing a secondary transfer, holding company and transferring the shares to a subsidiary company of a third company, if the transfer of shares is between related parties, section 188 does apply. So the view is, fresh issuance, don't worry of section 188. In secondary acquisition, do worry about section 188 also. And other things are, like when I close the deal after I've acquired, as we say at the closing, I'm very, very concerned that I should get the shares on that day, I should get my share certificates, I should get my DP account certificate, DP account statement to show this. So all of these are things which I ensure on the closing day. I want, on this, I'll pause it here, this forward dealing and insider trading, which is also, we keep in mind, and this is the few of the other challenges which we face, post-acquisition challenges are very, very critical. Right, you have acquired and there are two sets of people with different mindsets and all, these are these post challenges. So these are softer side of acquisition. You know, you should not stress so much and you should not become so bad or so acrimonious during your acquisition that eventually you will land up being with those people only. So I have listed out certain, most important I think are the contingent liabilities, hidden liabilities. Classic case which happened in brand Baxi. Daiichi acquired and there's a dispute that brand Baxi didn't tell to Daiichi that there is something happening wrong with the US Drug Administration. So these were hidden liabilities. So you have to be very, very after you acquire it. So that's it. I think reps and warranties is fine. Non-compete I have discussed. Section 27 of the Indian Contract Act allows non-compete only in the case of business transfer, business acquisition, slum sale. Thank you very much for your time and patience. Thanks so much.